Greetings students, I hope that you're all doing fine. In this lecture we will discuss a very important concept in Indian Contract Act of 1872, that is consideration. Now seeing that this particular topic has been asked in various PCSJ examinations across states, we would leave no stone unturned in making sure that we cover each and every aspect of this given topic. We need to holistically process and memorize various case laws and concepts that this broad topic deals with. So let's begin. So as you can see on your screen right now, we would start with the very definition of consideration. So what is consideration? There are many jurists which have defined it, and there are many legal scholars which have given their own opinion on it. In the words of Pollock, consideration is the price for which the promise of the other is bought, and the promise thus given for value is enforceable. Now the Calcutta High Court in Fazaluddin Mandal versus Panchanan Das has observed that consideration is the price of a promise, a written or quid pro quo, something of value received by the promisee as inducement of the promise. Now students, we know that section 2D of Indian Contract Act defines consideration as follows: when at the desire of the promiser, the promisee or any other person has done or abstained from doing, or does or abstains from doing, or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. So if we think about it, the definition of consideration in section D, it can actually be divided into three parts. Number one, that the act or abstinence which is to be a consideration for the promise should be done at the desire of the promiser. Number two, that it should be done by promisee or any other person. And number three, that the act or abstinence may have been already executed or is in the process of being done and may be still executory. That is to say, it is promised to be done. So what we're going to do right now is we're actually going to divide this given definition in three parts and talk about each aspect thoroughly. So firstly, we are going to talk about the desire of the promiser. So as the definition says, consideration must be at the desire of the promiser. So at the very offset, we are going to go through this important case law of Durga Prasad versus Baldio, whereby the facts were such that the plaintiff, on the order of the collector of a town, built at his own expense certain shops in a bazaar. The shops came to be occupied by the defendants, who, in consideration of the plaintiff, having expended money in the construction, promised to pay him a commission on articles sold through the agency in the bazaar. Now the plaintiff's action to recover the commission was rejected, and the reason was that, as the court held, the only ground for the making of the promise is the expense incurred by the plaintiff in establishing the ganj. But it is clear that anything done in that way was not at the desire of the defendant so as to constitute consideration. So the act over here, as we notice, is that it was not the result of the promise but rather of the collector's order. And this is where the UP PCSJ 2012 question comes in. Now analyze this question when I'm going to speak of it. M entered into an agreement with B and engaged Shiva for the purpose of performing puja and offering prayers to Lord Shiva for M's success in a suit, and promised to pay rupees 10,000 to B in the event of success. The suit ended into compromise, under which M obtained a substantial sum much beyond his expectations. M refuses to pay rupees 10,000 to B. B files a suit against M. Decide. So students, as you must have noticed, this question is actually based on the exact facts of the aforesaid case law of Durga Prasad versus Baldio that we just discussed. So in this answer, you must cite this case firstly, but more importantly and consequently, in the given problem, M will succeed. We need to conclude with that, and the reason why M will succeed in this suit is because performing puja and offering prayer to Lord Shiva is actually the consideration of the offer of M. So, talking about acts done at request. An act done at the promiser's desire furnishes a good consideration for his promise, even though it is of no personal significance or benefit to him. The decision of the Calcutta High Court in Kedarnath Bhattacharjee versus Gauri Muhammad has become well known in this connection. So in this given case, the facts, as you can see on the screen, were such that it was thought advisable to erect a town hall at Howrah provided sufficient subscription could be got together for the purpose. To this end, the commissioners of Howrah municipality set out to work to obtain necessary funds by public subscription. The defendant was a subscriber to this fund for rupees 100, having signed his name in the subscription book for that amount. On the faith of the promised subscriptions, the plaintiff entered into a contract with a contractor for the purpose of building the hall. But the defendant failed to pay the amount and contended that there was no consideration for the promise. There was no consideration for his promise. So, in this case, it was held that they were actually liable because persons were asked to subscribe knowing the purpose for which the money was to be applied. They knew that on the faith of their subscription, an obligation was to be incurred to pay the contractor for the work. So, the promise here was in consideration of your agreeing to enter into a contract to erect, I undertake to supply money for it. So, this given act, the act of the plaintiff in entering into contract with the contractor, was done at the desire of the defendant, who was the promiser in this case, and this particular act, it constituted consideration within the meaning of section 2D. Now, talking about promises of charitable nature, there has been a decision of Calcutta High Court in the Kedarnath case which we just discussed, which was actually followed by the Madras High Court judgment of Perumal Mudalayar versus Sendentha Mudalayar. Now, in this case, the Madras High Court held that a promise to pay a subscription becomes enforceable as soon as any definite steps have been taken in furtherance of the object and on the faith of the promised subscription. So we notice over here that it is not necessary that the given action must actually lead to something. If an action has been led due to faith of the promised subscription or any such promise, then it is enough to constitute consideration. So, in unilateral promises, we see that a unilateral promise from one side, it is actually a promise from one side only and is intended to induce some action by the other party. On that note, it has been held in Aloka Bose versus Paramatma Devi that a unilateral contract refers to a gratuitous promise where only one party makes a promise without any written promise. So that is a very general definition, as we already know. And the promisee is not bound to act, for he gives no promise from his side. But if he carries out the act desired by the promiser, he can hold the promiser to his promise. So, if you would recall, students, I had discussed this exact concept in my introductory video in this certification course. His act is at the same time an acceptance of and a consideration for the promise. It should be noted that in all the above cases where liability arose only when the promisee had, by doing some act on the faith of the promise, altered his position. So it follows therefore that where the promisee has done nothing, there is no consideration. Accordingly, in Abdul Aziz versus Masoom Ali, the defendant promised rupees 500 to a fund and started to rebuild a mosque, but nothing had been done to carry out the repairs and reconstruction. So over here, obviously, the subscriber was therefore held not liable. Now, talking about revocation of unilateral promises. So this is another problem concerning such unilateral contracts. It is true that a promise which is given in return for an act is revocable before the promisee begins to alter his position by acting upon the promise. But what if it is revoked after the promisee has commenced performance? If, for example, the promise is to pay a sum of money if the promisee walks from Lucknow to Kanpur. Now, in this case, can it be revoked after the promise has embarked upon the journey? After the promisee has embarked upon the journey, can the promise be revoked? So, the decision Kedarnath Bhattacharjee versus Gauri Muhammad suggests, though not in so many words, that such a revocation is impossible. The defendant in that case was held liable as soon as the contract for the construction of the hall was entered into. So, this is the law of the land. It is important to remember this. Now, in Errington versus Errington and Woods, whereby the owner of a house had mortgaged it, the house was in the occupation of his son and daughter-in-law. He told them that the house would become their property if they paid off the mortgage debt in installments and they commenced payment. So in these circumstances, the court felt that it would be unjust if the promisor could revoke this promise at his pleasure. His lordship said, the father's promise was a unilateral contract, a promise of the house in return for the act of paying the installments. It could not be revoked by him once the couple entered on performance of the act, but it would cease to bind him if they left it incomplete and unperformed. Now coming to promissory estoppel and government agencies. We see the case law of Delhi Cloth and General Mills Limited versus Union of India, whereby it was held that all that is now required is that the party asserting the estoppel must have acted upon the assurance given to him, or must have relied upon the representation made to him. It means that the party has changed or altered his position by relying on the assurance of representation. The alteration of his position by the party is the only indispensable requirement of the doctrine. It is not necessary to prove further any damage, detriment or prejudice to the party asserting the estoppel. Further, in Purnami Oil Mills versus State of Kerala, where the government was not permitted to go back on its earlier promise of wider exemption from sales tax in pursuance of which certain industries were set up, a subsequent notification curtailing the exemption was held to be applicable to industries established after the notification. Now, speaking of estoppel of licensee, it has been seen in Lake Raj versus State of Rajasthan, where the party who was granted a liquor license was held to be stopped from saying afterwards that some of the restrictions imposed upon his trade freedom, particularly the one under which the government reserved with it the power to vary issue prices, were unreasonable. So, in this case, it was seen that unreasonableness has to be considered in the totality of the circumstances, including public interest. So, liquor consumption has to be reduced, and therefore, free trade of such an item cannot be encouraged. And the power to vary issue prices is a method of actually exercising control of this trade. So, the courts will only prevent a crushing use of this power. And such power does not also offend Section 29 of the Contract Act, because there is no uncertainty about the nature of the price variation clause, and its unreasonable use can always be prevented under writ jurisdiction. In Colchester Borough Council versus Smith, whereby a person who had acquired title to the land of a council by adverse possession agreed subsequently to hold the same under a term license from the council. On the expiry of the term, the council told him to hand over possession. He tried to assert his title by adverse possession, but at this point he was not allowed to do so, because whatever rights he had acquired, they become substituted under the new arrangement which he voluntarily accepted. So the new arrangement, it actually constituted a promissory estoppel against him. So that actually covers the first bit, that is at the desire of the promisor or promissory estoppel. Now we are going to talk about privity of contract and of consideration, promisee or any other person. So this, students, as you must already know, is a very important topic again, a very important subtopic under the topic consideration, and we're going to make sure that we understand it thoroughly. So the second notable feature of the definition of consideration in section 2D is that the act which is to constitute a consideration may be done by the promisee or any other person. So it means therefore that as long as there is a consideration for a promise, it is actually immaterial who has furnished it. It may move from the promisee, or if the promiser has no objection, from any other person. This principle has its genesis in the English common law, having been adopted by the Court of King's Bench as early as 1677 in the case of Dutton versus Poole. So the facts of this case, as you can see on your screen, was that a person had a daughter to marry, and in order to provide her a marriage portion, he intended to sell a wood of which he was possessed at the time. His son, who was the defendant in this case, promised that if the father would forbear to sell at his request, he would pay the daughter £1,000. The father accordingly forbore, but the defendant did not pay. The daughter and her husband sued the defendant for the amount. So it was seen that it is clear that the defendant gave this promise to his father, and it was the father alone who, by abstaining from selling the wood, had furnished consideration for the promise. The plaintiff was neither privy to the contract nor interested in the consideration. But it is equally clear that the whole object of the agreement was to provide a portion to the plaintiff, and so it would have been highly inequitable to allow the son to keep the vote and yet to deprive his sister of her portion. So in this case, he was accordingly held liable. This is a very important case law. This is how it all starts. Remember this one. Now moving on, the possession of beneficiary who is not party. So after around 200 years after this case, in the case law of Tweedle versus Atkinson, the Court of Queen's Bench refused to follow the aforesaid principle. And the facts of this particular case were that the plaintiff was to be married to the daughter of one G, and in consideration of this intended marriage, G and the plaintiff's father entered into a written agreement by which it was agreed that each would pay the plaintiff a sum of the money. Now G failed to do so, and the plaintiff sued his executors. So in this case, Justice Whitman considered it to be an established principle that no stranger to the consideration can take advantage of a contract although made for his benefit. Now students, there is a reason why I am slowing down over here, because this actually came out to be a very important principle as we would go on to discuss. That no stranger to the consideration can take advantage of a contract although made for his benefit. So, although the sole objective of the contract was to secure a benefit to the plaintiff, he was not allowed to sue as the contract was made with his father and not with him. So, this case law is actually laid the foundation of what subsequently came to be known as the doctrine of privity of contract, which means that a contract is a contract between the parties only, and no third person can sue upon it even if it is overtly made for his benefit. So we come down to two fundamental propositions of English law. Number one, that consideration must move from the promisee and the promisee only. If it is furnished by any other person, the promisee becomes a stranger to the consideration and therefore cannot enforce the promise. And number two, a contract cannot be enforced by a person who is not a party to it, even though it is made for his benefit. He is a stranger to the contract and can claim no rights under it. Now we are going to talk about privity of consideration. So the former of these two propositions is not at all applicable in India. That is, in view of the clear language used in defining consideration in section 2D, it is actually not necessary that consideration should be furnished by the promisee. A promise is enforceable if there is some consideration for it, and it is quite immaterial whether it moves from the promisee or any other person. So the leading authority is the decision of the Madras High Court in Chinnaya versus Ramaya, a case law, a very important case law of 1882. In this case, an old lady by deed of gift made over certain landed property to the defendant, her daughter. By the terms of the deed, which was registered, and it was stipulated that an annuity of Rs 653 should be paid every year to the plaintiff, who was the sister of the old woman. Now the defendant on the same day executed in plaintiff's favor an ikernama, that is an agreement, promising to give effect to this stipulation. The annuity was however not paid, and the plaintiff sued to recover it. So it was clear that the only consideration for the defendant's promise to pay the annuity was the gift of certain lands by the old woman to the defendant. The defendant therefore tried to defend herself on the ground that the promisee, that is the plaintiff, had furnished no consideration. So briefly, the whole situation was this. The defendant's promise was given to the plaintiff, but consideration was furnished by the plaintiff's sister. The court could have easily allowed the plaintiff to recover the annuity as consideration given by any other person is equally effective, but the court reached the same result but on a somewhat different ground. So Justice Innes tried to equate the situation with the facts of Dutton versus Poole. In that case, the defendant's sister would have got her marriage portion but for the defendant's promise. In the present case also, it appeared that the plaintiff was already receiving from her sister an annuity of like amount of the state, and when the state was handed over to the defendant, it was stipulated that the payment to the plaintiff should be continued, and she promised accordingly. That means that the failure to keep the promise would have deprived the plaintiff of an amount which she was already receiving, and it is a legal commonplace that if a promise causes some loss to the promisee, that is sufficient consideration for the promise. Thus, the plaintiff had given consideration. Now, in 2013, a UPPCSJ question was asked. It was an assertion reasoning question, whereby assertion was that agreement without consideration is void, and the reasoning was that consideration may be given by promisee or any other person. So over here we notice that the first statement is actually true, and so is the second statement. But the second statement is not actually the reason why the statement 1 is correct. So B was held to be the correct answer here. Now, in terms of India, we are going to talk about privity of contract. So this, like whatever we have discussed so far, that is the English propositions, and we have related it to the Indian case law, that of Chennai versus Ramaya, only to point out that the first fundamental proposition under English law, that is consideration must move from the promisee and the promisee only. If it be furnished by any other person, the promisee becomes a stranger to the consideration and therefore cannot enforce the promise. We discussed the case of Chennai versus Ramaya to clarify that this given provision is actually not true in India. But in general, we are going to talk about the position in India regarding the privity of contract. So firstly, we are going to talk about the decisions in India which have actually followed the English law. So there has been a great divergence of opinion in the courts as to how far a stranger to a contract can enforce it. There are many decided cases which declare that a contract cannot be enforced by a person who is not a party to it, and that the rule in Tweddle versus Atkinson is as much applicable in India as it is in England. But there is no provision in the Contract Act either for or against the rule. And the Privy Council extended the rule to India in its decision in Jamna Das versus Pandit Ram Authored Pandey. So remember this case law, student, it is for the English law decisions. In this case, A borrowed rupees 40,000 by executing a mortgage of her zamindari in favor of B. Subsequently, she sold the property to C for rupees 44,000 and allowed C, the purchaser, to retain rupees 40,000 of the price in order to redeem the mortgage if he thought fit. Now B sued C for the recovery of the mortgage money, but he could not succeed because he was no party to the agreement between A and B. Lord Macnaghten, in his very short judgment, said that the undertaking to pay back the mortgagee was given by the defendant to his vendor. The mortgagee has no right to avail himself of that. He was no party to the sale. The purchaser entered into a no contract with him, and the purchaser is not personally bound to pay this mortgage debt. So, we see that the decisions not following English law, and most important of them is that of Nawab Khwaja Muhammad Khan versus Nawab Hussaini Begum. In this given case law, the Privy Council actually judged the given case, and it was held that in India and among communities, as the Lordship observed, these communities in India and among communities circumstanced as the Mohammedans, among whom marriages are contracted for minors by parents and guardians, it might occasion serious injustice if the common law doctrine was applied to agreements or arrangements entered into in connection with such contracts. So this statement has been taken by some high courts as laying down the rule that the Indian courts are not bound by the rule in Tweddle versus Atkinson. Accordingly, it has been observed by the Madras High Court that there is ample authority for the proposition that in this country, and indeed in a certain class of cases in England where a contract is made between A and B for the benefit of C, C is entitled to sue the defaulting party. So it is unnecessary to cite authorities, but the principle is firmly established for this country by the decision of the Privy Council in Nawab Khwaja Muhammad Khan versus Nawab Hussaini Begum. And this is one of the important case laws which we must remember at all times whenever we talk about privity of contract. Now, having successfully discussed the privity rule, we are going to talk about the exceptions to this privity rule. So students, we see that in the course of time, the courts have introduced a number of exceptions in which the rule of privity of contract does not prevent a person from enforcing a contract which has been made for his benefit but without his being a party to it. Many of the exceptions are actually connected with the special branches of the law of contracts, such as negotiable instruments, agency, bill of lading, railway receipts, transfer of property, etc. Some of the most commonly known exceptions may be considered here. Number 1, beneficiaries under trust or charge or other arrangements. So in this given category, we notice that a person in whose favor a charge or other interest in some specific property has been created may enforce it, though he is not a party to the contract. The decision of the Privy Council Nawab Khwaja Muhammad Khan versus Nawab Hussaini Begum is illustrative of this principle. The facts of this given case law, which we have mentioned 3 times now, were that the appellant executed an agreement with the respondent's father that in consideration of the respondent's marriage with the son, that is both being minors at the time, he would pay to the respondent rupees 500 a month in perpetuity for the betel leaf expenses and charge certain properties with the payment, with power to the respondent to enforce it. The husband and wife separated on account of a quarrel, and the suit was brought by the plaintiff, that is respondent, for the recovery of the arrears of this annuity. Now it was held that the respondent, although no party to the contract, was clearly entitled to proceed in equity to enforce her claim. Here the agreement executed by the defendant specifically charges immovable property for the allowance which he binds himself to pay to the plaintiff. She is the only person beneficially entitled under it. So, coming to the second category, which is that of marriage settlement, partition or other family arrangements, we notice that where an arrangement is made in connection with marriage, partition or other family arrangement, and a provision is made for the benefit of a person, he may actually take advantage of that agreement although he is no party to it. For example, in Rose Fernandez vs. Joseph Gonzalez, a girl's father entered into an agreement for a marriage with the defendant, and it was held that the girl, after retaining majority, could sue the defendant for damages for breach of the promise of marriage, and the defendant could not take the plea that she was not a party to the agreement. And the third category, that is of acknowledgement or estoppel, we notice that where by the terms of a contract, a party is required to make a payment to a third person and he acknowledges it to that third person, a binding obligation is thereby incurred towards him. Acknowledgement may be expressed or implied. So this exemption covers cases where the promisor by his conduct, acknowledgement or otherwise constitutes himself an agent of the third party. So it has been held in N. Dev Raje versus M. Ramakrishnan, whereby A sold his house to B under a registered sale deed and left a part of the sale price in his hands, desiring him to pay this amount to C, that is his creditor. And subsequently B made part payments to C, informing him that they were out of the sale price left with him and that the balance would be remitted immediately. But B, however, failed to remit the balance and C sued him for the same. Here it was held that the suit was maintainable. So because though originally there was no privity of contract between B and C, B having subsequently acknowledged his liability, now C was entitled to sue him for recovery of the amount. So an illustration of acknowledgement by conduct is this given case law that you can see on the screen. Shiro de Bihari Datta versus Mango Binda Panda. So in this case, whereby the tenant and the subtenant of a piece of land agreed between themselves that the subtenant would pay the tenant's rent direct to the landlord, and the agreement was acted upon by all the parties interested. Under these circumstances, it was held that the landlord was allowed to obtain a decree for his rent direct against the subtenant. In other words, the subtenant was stopped from denying his liability to pay the tenant's rent on the ground that there was no such contract between him and the landlord. Now, coming to the fourth exception, that is covenants running with land. The rule of privity may also be modified by the principles relating to transfer of immovable property. So, this principle was seen in the famous case of Tulp versus Moxey, whereby the principle was that a person who purchases a land with notice that the owner of the land is bound by certain duties created by an agreement or covenant affecting the land shall be bound by them although he was not a party to the agreement. And an illustration of this principle is seen in the case law of Smith and Snipes Hall Farm Limited versus River Douglas Catchment Board, whereby the facts were such that the defendant, that is the board, agreed with certain landowners adjoining a stream to improve the banks of the stream and to maintain them in good condition. The landlords on their part paid proportionate costs. Subsequently, one of the landlords sold his land to the first plaintiff and he to the second plaintiff. So there was negligence on the part of the board in maintaining the banks which burst and the land was flooded. In this case, both the plaintiffs were stranger to the agreement with the board, but even so the Court of Appeal allowed them to sue the board for breach of the contract, for the whole arrangement was for the benefit of the landowners, whoever they might be, and not merely the parties to the agreement. So this was the reason. So in UPPCJ 2013, a question was asked, means question, whereby the question read that a contract cannot be enforced by a person who is not a party to it, even though it is made for his benefit. Point out also the exceptions to this rule, discuss and refer to decided cases. So students, I genuinely hope that after thoroughly discussing the Indian and English position on this given concept of privity of contract, which we also coupled with the exceptions to this rule, that you can actually answer this question optimally. Still, in case there is any doubt, you can always hit me up with your queries. Now coming to the third aspect of the definition, that is has done or abstained from doing. So these words mean that consideration is an act or abstinence which has already been done at the desire of the promiser, or is in progress, or is promised to be done in future. An act which has already been done in response to the promise is referred to as executed consideration. So, what is a past consideration? It is an age-old principle of English law that consideration should be contemporaneous with the promise. Consideration, being the price for the promise, should be given in response to and as an inducement for the promise. If the act has been done before any promise is made, it is called past consideration, and a past consideration is actually no consideration. If, for example, A has lost his purse and B, a finder, delivers it to him, A, in recognition of the service, promises to pay B a sum of money. This promise is given for an act which was done before any promise existed, and therefore cannot be said to have been done as a price for the promise. So the promise is to pay for a wholly past act and is therefore no more than an expression of gratitude. It is seen in the case law of Roscoe versus Thomas, whereby the court held that the past act may explain why the promise was given and may thus be a motive for the promise, but it furnishes no legal consideration. Now in UPPCJ 2003, we see another prelims question, whereby the question read, which of the following agreements is not void? In option A, we have an agreement whereby A agrees to sell 200 tons of oil to B. Obviously, this is not a valid agreement. Second, an agreement in restraint of legal. Obviously, even this cannot be. An agreement in restraint of marriage. All the three agreements, they are void. We can genuinely see that as we're going to discuss in the given lectures. It will become clear for you why they are. But for now, I want you to focus on this fact, that is the option D, whereby there is an agreement in which A finds B's purse and gives it to him, and B promises to give A rupees 100. So you must have noticed that this given concept actually goes against the English law which we just discussed, because in Indian law it is fine that there is a situation that for example, in this given situation, A finds B's purse and gives it to him, B promises to give A rupees 100. So there was no consideration initially, but that does not matter. So we're going to discuss why and how. Now, but before that, we're going to talk about past act at request, good consideration. So, an important exception is almost as old as the rule itself. It was established as early as 1616 in Lampley versus Brathwaite that the past act done at request will be good consideration for a subsequent promise. The facts were, the defendant, having committed a murder, requested the plaintiff to labour and to do his endeavour to obtain pardon from the king. The plaintiff did his best to obtain the king's pardon, riding and journeying at his own expense. Afterwards, the defendant promised the plaintiff to give him £100 and then refused to pay. He was, however, held liable. So the modern version of this rule is that in such cases, it is ordinarily in the contemplation of the parties that the service rendered at request would be ultimately paid for, and that subsequent promise is nothing but a fixation of reasonable compensation for the service. Besides this, two more exceptions have been admitted: a promise to pay a time-barred debt and a negotiable instrument issued for a past consideration. These two given exceptions, they have also been admitted and their consideration are valid. So now that we have discussed the English position on this given concept, we are going to talk about the position in India. And in Dev Kuti Amma versus Madhusudan Nayyar, it was seen that the past consideration is actually good consideration under the Indian Contract Act, and that is a deviation from the English common law, and that it is not necessary for the courts in India to follow the English rule as to past consideration. So this is what I was talking about earlier, students, when I discussed with you the UPPCSJ question. So a past consideration may arise in two ways. It may consist of services rendered at request but without any promise at the time, or it may consist of voluntarily services. So past voluntary service is adequately covered by the provision in section 25(2). A voluntary service means a service rendered without any request or promise, and there is a subsequent promise to pay for the same. For example, to borrow an illustration from Anson, if A saves B from drowning and B later promises A reward, then in English law, A cannot rely on his action as consideration for B's promise, for it is past in point of time. But in India, the promise would be enforceable by virtue of section 25(2), which provides that a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor is enforceable. So the Act gives the following two illustrations to explain this. Number 1. A finds B's purse and gives it to him. B promises to give A rupees 50. This is a contract. Number 2. A supports B's infant son. B promises to pay A's expenses in so doing. This is a contract. Now talking about the past service at request. So this is the only area of certainty. That is because it is not adequately covered either by section 2D or by section 25B. Section 2D requires that the act should be done at the promiser's desire. So this presupposes the existence of a promise to pay for the act, and even when construed literally, the provision cannot apply to an act done at request but without any promise to pay. But the provision can be construed to include an act which has been done at request and for which a promise to pay is given subsequently. Even if no subsequent promise is given, the courts can, following the principle laid down in Upton on Servant RDC versus Powell, infer an implied promise. So every request for an act carries an inbuilt promise to pay. This is the idea that we're talking about here. Now talking about past and executed consideration. A past consideration should, however, be distinguished from executed consideration. Past consideration always consists of an act done without any promise. But executed consideration means an act which has been done in finding a lost article. The offer can be accepted only by producing the article to the offerer, and that is also a consideration for the promise. It is thus an example of a consideration which has already been executed. So explaining this in Union of India versus Chaman Lal Luna and Company, Justice S.K. Das of Supreme Court said that an executed consideration consists of an act for a promise. It is the act which forms the consideration. No contract is formed unless and until the act is performed. For example, the payment for a railway ticket. But the act stipulated for exhausts the consideration, so that any subsequent promise without further consideration is merely a nudum pactum. Now we're going to discuss in one of the coming questions what is actually nudum pactum. So he also said that in an executed consideration, the liability is outstanding on one side only. It is a present as opposed to a future consideration. Now, what is an executory consideration? So, consideration may consist of an act which has already been or is in the process of being done. It may also consist of an act which is only promised to be done at some future time. So, there may be a simple exchange of promises and each promise is a consideration for the other. For example, A agrees to sell and B to buy a quantity of goods at a stated price. In other words, A has promised to sell and B has promised to pay. So until the goods are actually delivered to B, under the contract, the consideration is executory. So till the time the goods are actually delivered to B as stated in the contract, the consideration is executory. Now coming to the part that says such act, abstinence or promise is called consideration. So the idea over here of this subtopic is to discuss that consideration must be of some value. So consideration as defined in the act means some act, abstinence or promise on the part of the promisee or any other person which has been done at the desire of the promiser. Now, does it therefore mean that even a worthless act will suffice to make a good consideration if it is only done at the promiser's desire? For example, A promises to give his new Rolls-Royce car to B, provided B will fetch it from the garage. So, if we notice, the act of fetching the car cannot by any stretch of imagination be called a consideration for the promise. And yet, it is the only act the promiser desired the promisee to do. So, such an act no doubt satisfied the words of the definition, but it does not catch its spirit. It is for this reason that the English common law has always insisted that consideration must be of some values in the eyes of the law. In India also it has been laid down by Justice Sabarao of the Supreme Court in the case of Chidambara Iyer versus P.S. Renga Iyer that consideration shall be something which not only the parties regard but the law can also regard as having some value. Similarly, it has been observed by the Madras High Court in the case law of Kulasekaral Perumal versus Pathakutti Thalevener that though the Indian Contract Act does not in terms provide that consideration must be good or valuable to sustain a contract, it has always been understood that consideration means something which is of some values in the eyes of the law. It must be real and not illusory, whether adequate or not. So long as the consideration is not unreal, it is sufficient if it be of slight value only. Now, what if the value, does the value need to be adequate or not? I know we have already discussed it in the first video, I think, but we are going to talk about it again. So, it is however not necessary that consideration should be adequate to the promise. It has been held in Bolden vs. Madden that the adequacy of the consideration is for the parties to consider at the time of making the agreement, not for the court when it is sought to be enforced. This is the English rule and is also applicable in India. For explanation 2 attached to section 25 lays it down so clearly that an agreement to which the consent of the promisor is freely given is not void mainly because the consideration is inadequate. Now this is further fortified by the illustration which is as follows. A agrees to sell a horse worth ₹1,000 for ₹10. A's consent to the agreement was freely given. The agreement is a contract notwithstanding the inadequacy of the consideration. So we come to the concept of forbearance to sue. So forbearance to sue has also been regarded as valuable consideration. It is indeed a kind of abstinence which is so very clearly recognized as good consideration in the definition itself. Forbearance to sue means that the plaintiff has a right of action against the defendant or any other person and on a promise by the defendant, he refrains from bringing that action. So the Patna High Court observed in Devi Radharani versus Ramdas that where a wife who was ready to sue her husband for maintenance allowance had forborne to sue on husband's agreeing to pay her monthly allowance by way of maintenance, the contract was actually supported by consideration, as wife's forbearance to sue amounted to consideration for husband's agreement for payment of maintenance allowance. Now, talking about the compromise, which is the last aspect that we will be discussing under this, it is understood that compromise of a pending suit is also a good consideration for the agreement of compromise. So, it is essential at the same time that the dispute should be bona fide. Although the Patna High Court in Rameshwar Mistri versus Babulal Pandit has held that a compromise is binding even if the suit was based on a false claim. And it has also been held in United Province Government versus Church Missionary Trust Association Limited that a compromise is a good consideration irrespective of merits of the claim of either side, and even when there is some doubt in the minds of the parties as to their respective rights. Now we're going to talk about another important subtopic under this, that is performance of existing duties. So under this we have varieties of existing duties, one of which is performance of legal obligations. So consideration, it is generally said, must be something more than what the promisee is already bound to do. A person may be bound to do something by law or by contract. Performance of a legal duty is no consideration for a promise. So this principle of English law was actually adopted by the Madras High Court in P. Shashana Chetty versus Rama Swami Chetty. So even before the Contract Act came into force, this given principle was adopted, although the Act contains no provision on the point. And the facts of this case were that the plaintiff had been served with summons requiring him to give evidence before a court of law. The defendant, who was a party to the case, gave him a promissory note promising to pay a sum of money for his trouble. The note was held to be void for want of consideration, and the court observed, it is quite clear that if a subpoena had been served and the note had been given to compensate the plaintiff for his loss of time or other inconvenience, it would have been without consideration, because his attendance and the giving of evidence would have been merely the performance of a duty imposed upon by law. So, we also have cases of performance of contractual obligations, in which the first category is that of pre-existing contract with promisor. So, compliance with legal obligation imposed by a contract with the promisor can be no consideration for a promise. And this can be illustrated by the case of Ramchandra Chintaman versus Kalu Raju. In this case, the plaintiff accepted a wakalatnama from the defendant to act for him in a certain suit on reviewing his usual fee. Subsequently, the defendant agreed to pay him a certain sum as a special reward if the suit was decided in his favor. Now, the suit was decided in favor of the defendant, who, however, did not pay the amount. The plaintiff therefore brought the present suit against him, and rejecting the action, Chief Justice Westrop said that the plaintiff have accepted a wakalatnama which was already bound to render his best service as a pleader. So the plaintiff, having accepted a wakalatnama, was already bound to render his best service as a pleader. There was no fresh consideration proceeding from the plaintiff when he obtained the agreement. Now, promise to pay less than amount due. That makes for another category under performance of contractual obligations. So, on the same principle, a promise to pay less than what is due under a contract cannot be regarded as a consideration. This rule, having been laid down in an early case, was thus formulated in Penny versus Cole, which was also famously known as Pinnell's case. Now, in this Pinnell's case, the facts were such that payment of a lesser sum on the day in satisfaction of a greater cannot be any satisfaction for the whole, because it appears to the judges that by no possibility can a lesser sum be a satisfaction to the plaintiff for a greater sum. But the gift of a horse, hawk or robe, etc. in satisfaction is good, for it shall be intended that a horse, hawk or robe, etc. might be more beneficial to the plaintiff than the money in the respect of some circumstances, or otherwise. The plaintiff would have not otherwise accepted of it in satisfaction. So in this Pinnell's case, it was observed that payment of a lesser sum on the day in satisfaction of a greater cannot be any satisfaction for the whole, because it appears to the judges that by no possibility can a lesser sum be a satisfaction to the plaintiff for a greater sum. But the gift of a horse, hawk or robe, etc. in satisfaction is good, for it shall be intended that a horse, hawk or robe, etc. might be more beneficial to the plaintiff than the money in respect of some circumstances, or otherwise. The plaintiff would have not accepted of it in satisfaction. But this rule, it was criticized in the case of Coldery versus Bartram. In this case of Coldery versus Bartram, the court said, according to the English common law, a creditor might accept anything in satisfaction of his debt except a less amount of money. So we notice that there are exceptions to the rule in Pennell's case. The courts, they have tried to avoid the awkward results of the rule by admitting exceptions to it. So one of the exceptions is that of part payment by a third party. So in the first place, part payment by the third party may be actually a good consideration for the discharge of the whole of the debt. And it has been seen in Hira Chand Punam Chand versus Temple, whereby the facts versus that the father of a debtor wrote to the creditor offering an amount less than that of the debt in full settlement of the debt and enclosing a draft for that amount, and the creditor cashed and retained the proceeds of the draft and afterwards brought an action against the debtor for the balance of the debt. So here it was held that the creditor must be taken to have accepted the amount received by him on the terms upon which it was offered, and therefore he could not maintain the action. Another exception is that of composition, whereby payment of a lesser sum is a good satisfaction for a larger sum, where this is done in pursuance of an agreement of compromise entered into by the debtor with his creditors. Another exception is that of payment before time, as we naturally understand that payment of a lesser sum before time or in a different mode or at a different place than appointed in the original contract, or the gift of a horse, hawk or robe, etc. in satisfaction is good. Now we would come to the most important exception to this principle, that is promissory estoppel. So, referring to the above principle in his judgment in Combe versus Combe, Learned Denning said that principle does not create new cause of action where none existed before. It only prevents a party from insisting upon his strict legal rights when it would be unjust to allow him to enforce them, having regard to the dealings which have taken place between the party. Now in this case, students, a wife obtained a decree nisi against her husband for divorce. So, decree nisi is nothing but a decree which is not final. So she received a letter from the husband in confirmation of her own, as exchanged through solicitors, that he would make her £100 allowance a year. But the husband did not make the payments, and ultimately the wife brought an action to enforce the promise. So the Court of Appeal held that neither there was any consideration for promise, nor was there any promissory estoppel against the husband. The husband never made a request that she should not enforce a normal right to maintenance, nor was there any undertaking on her part not to do so. So her abstinence was not the result of any promise of the husband. Though promissory estoppel may not sustain a new cause of action, it is not necessarily confined to cases where the parties are bound by subsisting contract and one of them promises not to enforce his normal contractual rights. So, the decision of the Court of Appeal in Evenden versus Guildford City Association Football Club Limited marks a further extension of the boundaries of promissory estoppel. In this case, Lord Denning stated that the doctrine of estoppel applies whenever a representation is made, whether of fact or law, present or future, which is intended to be binding, intended to induce a person to act on it, and he does act on it. The facts were that the plaintiff had been working since 1955 as a groundsman in a supporters club of a football club. In 1968, the football club itself acquired his services on the same terms and for the same work. In 1974, he was made redundant. So he claimed redundancy benefit right from 1955, whereas the club proposed to pay him only from 1968. The principle of promissory estoppel was applied because there was a representation that his employment would be treated as continuous. The court said that the representation was intended to be binded and intended to be acted on. He did act on it. He did not claim from the supporters club the redundancy payment to which he would otherwise have been entitled from that club. 6 months later, his claim against the supporters club was barred by lapse of time. It would be most unfair for the football club to go back now on that representation. The employment must be treated as continuous for 19 years. So, in PCSJ, UP PCSJ 1991, a question was asked in mains. Write short notes on any of the following, whereby the question referred to doctrine of promissory estoppel. We had to write short notes on this point. So, if a question came again, and it certainly will in the coming PCSJ examinations, be it of any state, we need to remember the following points. The principle of estoppel in India is a rule of evidence incorporated in Section 115 of the Indian Evidence Act of 1872. The section reads as follows. When one person has, by his declaration, act or omission, intentionally caused or permitted another person to believe such a thing to be true and to act upon such belief, neither he nor his representative shall be allowed in any suit or proceeding between himself and such person or his representative to deny the truth of that thing. The ingredients for the application of the doctrine are: number one, that there was a representation or promise in regard to something to be done in the future. Number two, that the representation or promise was intended to affect the legal relationship of the parties and to be acted upon accordingly. And number three, that it is one on which the other side has, in fact, acted to its prejudice. So in India, we see that there are two stages in the evolution of the application of this doctrine: pre-Anglo-Afghan case and post-Anglo-Afghan case. Prior to this case, the position was that promissory estoppel did not apply against the government, but the position altered with this case. So in Union of India versus Anglo-Afghan agencies, it was seen that the government of India announced certain concessions with regard to the import of certain raw materials in order to exchange export of woolen garments to Afghanistan. Subsequently, only partial concessions and not full concessions were extended as announced. So the Supreme Court held that the government was stopped by its promise. Thereafter, the courts have applied the doctrine of promissory estoppel even against the government. So under performance of existing duties, when we talk about promise to pay less than amount due, we realize that the position in the Indian Contract Act is actually different, because controversies of this kind are not likely to arise, for the Contract Act in section 63 clearly provides that every promisee may dispense with or remit wholly or in part the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it any satisfaction which he thinks fit. The section also has following illustrations. A owes B 5,000 rupees, A pays to B and B accepts in satisfaction of the whole debt. 2,000 rupees paid at the time and place at which the 5,000 rupees were payable. The whole debt is discharged. A owes B rupees 5,000, C pays to B 1,000 rupees and B accepts them in satisfaction of his claim on A. This payment is discharge of the whole claim. A owes B under a contract a sum of money, the amount of which has not been ascertained. A, without ascertaining the amount, gives to B, and B, in satisfaction thereof, accepts the sum of 2,000 rupees. This is discharge of the whole debt, whatever may be its amount. And lastly, A owes B 2,000 rupees and is also indebted to other creditors. A makes an arrangement with his creditors, including B, to pay them a composition of 8 annas in the rupee upon their respective demands. Payment to B of 1,000 rupees is a discharge of S's demands. So we realize, students, that the position under Indian Contract Act is clearly different, and section 63 helps us confirm the Indian position. So in the case of Narayan Rao Jagobji Gowande Public Trust versus State of Maharashtra, whereby there was a development agreement between an improvement trust and a landowner, and a clause in the agreement provided that the owner is to transfer the plot earmarked for a primary school to the trust free of cost. It was held to be not void for being without consideration or being opposed to public policy. The landowner had under the agreement derived a huge benefit by getting his land freed from acquisition and also getting permission to develop the land and put it to commercial use. Now, coming to the B category, that is pre-existing contract with third party, the second category of contractual obligations. So we realize that where a person is contracted to do an act and the third person promises to pay him a sum of money if he would go ahead with the performance, is there a consideration for the promise? So a situation like this arose in Shadwell versus Shadwell, whereby the plaintiff was already engaged to be married to a girl named Ellen Nicole, and his uncle, the defendant, sent him the following letter. I am glad to hear of your intended marriage with Ellen Nicole, and as I promised to assist you at starting, I am happy to tell you that I will pay to you £150 yearly during my life, and until your annual income derived from your profession of a chancery barrister shall amount to 600 guineas. So the question was that was the consideration for the uncle's promise? What was the consideration for the uncle's promise? And the court, with its majority judgment, which was delivered by Earl Chief Justice, the court actually found sufficient consideration to sustain the promise. According to his lordship, the promise of the annuity might have been intended as an inducement to the marriage. The plaintiff may have made the most material changes in his position and have incurred pecuniary liabilities resulting in embarrassments which could be in every sense a loss if the income which had been promised should be withheld. So his lordship also noted that there was some benefit to the promiser, as the marriage of a near relative is always an object of interest. Now, the principle of this case has been followed in India by the High Court of Madhya Pradesh in the case of Firm Gopal Company Limited versus Firm Hazari Limited Company. In this case, the fact was that the plaintiff was under a contract to purchase some bales of cotton from a mill but refused to fulfill a substantial part of his contract as the prices of cloth had fallen down. Now, the defendants, who were the sole selling agents of the mill and who had guaranteed the performance of the contract, requested the plaintiff to take the whole of the quota of bales fixed for delivery in the first month and promised that they would buy from the plaintiff a part of such bales at the contract price or pay him rupees 25,000 at his option. But the plaintiff complied with their request and elected to take rupees 25,000. And then the defendants contended that their promise was void for want of consideration, as the plaintiff was already bound to take the cotton. Now, the court here reviewed English authorities and said, from these decisions, it appears that the second agreement brings into existence a new contract between different parties, and therefore a promise to do a thing which the promisee is already bound to do under a contract with a third party can be a good consideration to support a contract. Now, on the topic of consideration and motive, we must notice that a certain distinction lies between motive and consideration. Motive is not the same thing with consideration. This well-known phrase occurs in the judgment of Justice Patterson in Thomas versus Thomas, whereby the fact was that a testator, on the day of his death, had verbally said in front of the witnesses that he was desirous that his wife should enjoy certain premises for her life. The executors, who were also the assignees, in consideration of such desire and of the premises, agreed. The executors, who were also the assignees in consideration of such desire and of the premises, agreed with the widow to convey the premises to her, provided she would pay to the executors the sum of £1 yearly towards the ground rent and keep the said house in repair. Now, on the question of consideration for the agreement between the executors and the widow, the court pointed out that the motive for the agreement was unquestionably respect for the wishes of the testator. But that was no part of the legal consideration for the agreement. Motive should not be confounded with consideration. The agreement was, however, held to be binding, as the undertaking to pay the ground rent was a sufficient consideration. Now, a case where there was an absence of consideration, or a scenario where there should be, or how to decide whether there is absence of consideration. For this, we have one case law of Atma Singh versus Lakshman Das, a recent case of 2009, where the promissory note was apparently genuine, neither forged nor fabricated. The lender was allowed to recover the loan amount with interest. Here the court said that a bare denial of the passing of consideration does not make any defense. Something which is probable has to be brought on record so that the court may either believe that the consideration did not exist, or that its non-existence was so probable that a prudent man would, under circumstances of the case, act on the belief that it did not exist. Now, that covers consideration, everything about considerations, except the exceptions to consideration, which we are going to discuss now. So, under the English law, we see that contracts under seal in English law, that is, in English law, contract under seal is enforceable without consideration. So that is the biggest exception to consideration. In the words of Anson, English law recognizes only two kinds of contracts: the contract made by a deed that is under seal, which is called a deed of speciality, and the simple contract. So a contract under seal means a contract which is in writing and which is signed, sealed and delivered. Now, when we talk about the Indian position, exceptions under Section 25 Contract Act, we see that Section 25 of the Contract Act, it lays down a few exceptions. Now I'm going to read out Section 25 for you as laid down on the screen. An agreement made without consideration is void unless, number 1, it is in writing and registered, that is, it is expressed in writing and registered under the law for the time being in force for registration of documents, and is made on account of natural love and affection between parties standing in a near relation to each other. Or unless, number 2, it is a promise to compensate for something done, that is, it is a promise to compensate wholly or in part a person who has already voluntarily done something for the promisor, or something which the promisor was legally compellable to do. Or unless, number 3, it is a promise to pay a debt barred by limitation law. That is, it is a promise made in writing and signed by the person to be charged therewith, or by his agent generally or specially authorized in that behalf, to pay wholly or in part of a debt of which the creditor might have enforced payment, but for the law for the limitation of such. Now, if you would have noticed, students, I actually went slow to emphasize on areas which needed emphasis, and we're going to discuss the same for the lecture. Now, continuing with the Section 25. In any of these cases, such an agreement is a contract. So there is an explanation. Explanation 1. Nothing in this section shall affect the validity as between the donor and donee of any gift actually made. Explanation 2. An agreement to which the consent of the promisor is freely given is not void merely because the consideration is inadequate. But the inadequacy of the consideration may be taken into account by the court in determining the question whether the consent to the promisor was freely given. Now we have illustrations. There are 6 illustrations, actually 7 illustrations. Illustration 1. A promises for no consideration to give to B rupees 1000. This is a void agreement. This is illustration B. A for natural love and affection promises to give his son B rupees 1000. A puts his promise to S into writing and registers it. This is a contract. C. A finds B's purse and gives it to him. B promises to give A rupees 50. This is the contract. D. A supports B's infant son. B promises to pay A's expenses in so doing. This is a contract. E. A owes B rupees 1000, but the debt is barred by the Limitation Act. A signs a written promise to pay rupees 500 to B on account of the debt. This is a contract. Illustration F. A agrees to sell a horse worth rupees 1000 for rupees 10. A's consent to the agreement was freely given. The agreement is a contract notwithstanding the inadequacy of the consideration. Illustration G. A agrees to sell a horse worth rupees 1000 for rupees 10. A denies that his consent to the agreement was freely given. Now here, the inadequacy of the consideration is a fact which the court should take into account in considering whether or not A's consent was freely given. Now, since we have discussed Section 25, before continuing with what we are going to continue with, I'm going to discuss with UPPCSJ 1992 mains question with you, which said that define consideration and state the circumstances in which an agreement made without consideration is valid. Explain with an illustration. So, in this question, students, you have to mention the definition of consideration in section 25 with its explanation and illustrations as mentioned aforesaid. At the same time, you need to remember that in such questions, it is important to stick to what the question is asking and resist yourself from pouring down on the paper everything that you know on the given topic. So I feel that for this question, all that you needed to do was mention the definition of consideration section 25 with its explanation and illustrations as mentioned aforesaid. That would concisely answer what the question demands. Now, as you can see on the screen, questions have been asked on consideration like anything. Multitudes of questions have been asked on the same broad topic. Nothing is better than this given idea that you see on the screen right now. Imagine how convenient it is for you to score. A question was asked in 1997, asked in 2006, asked in 2012, asked in 2016, before that in 1992. I mean, it is almost certain that a question is going to come in the next PCSJ examination. When UP PCJ, and this is only the UP, this is only the state of UP that I'm discussing with you, because while discussing questions, it is important to stick to a state, because if I would go on to discuss with you each and every state's question, it would become really difficult to stick to the given concepts, because the discussion would become much lengthier. So if you, as you can see, if UP is itself asking so many questions on consideration, then you can only imagine how important this concept is. So you can see in UP PCJ 1997, question was asked, what do you mean by consideration? Is an agreement made without consideration is valid? In UP PCJ 2006, a question said, subject to certain exceptions, an agreement without consideration is nudum pactum and is also void discussed. So nudum pactum, as I had mentioned earlier, in Latin it literally means naked promise or bare promise. In common law, it refers to a promise that is not legally enforceable for want of consideration. Then in UP PCJ 2012, a question was asked, an agreement without consideration is void, explain what are the exceptions to this rule. So you can see, students, you need to just remember, just process a concept, memorize it, and keep on revising it. That's all that you need to do for consideration. Then again, UP PCJ 2016, a question was asked, an agreement without consideration is void, what are the exceptions to this rule? Discuss. Exactly the same question. So you can clearly see how easy it is to score marks in examinations only if we solve the previous year questions as exact same questions are repeated in the subsequent examinations. Now that we have discussed the questions on consideration and its exceptions, we are going to talk about the exceptions themselves. So just to begin with, the very first one, as mentioned in the definition, natural love and affection. So the essence of the first exception is that a written and registered agreement based on natural love and affection between near relatives and is enforceable without consideration. But who is a near relative? The Act provides no guidance, nor has the expression been judicially construed. The expression will, without doubt, include parties related by blood or marriage. Again, what is meant by natural love and affection? There is always some degree of instinctive love and affection between parties nearly related, but this instinct may sometimes be overruled by external circumstances. Thus, for example, in Rajlikhi Dabi versus Bhutnath Mukherjee, it was seen whereby the defendant promised to pay his wife a fixed sum of money every month for her separate residence and maintenance, and there was an agreement which was contained in a registered document which mentioned certain quarrels and disagreements between the two. In this case, the Calcutta High Court refused to regard the agreement as one covered by the exception. The court could find no trace of love and affection between the parties whose quarrels had compelled them to separate. With this should be contrasted the decision of the Bombay High Court in Bhiva versus Shivaram, in which A sued B, his brother, for a share in certain lands. But the suit was dismissed as B solemnly affirmed that the property was not ancestral. B then agreed by registered writing to give A one half of the same property. The present suit was brought to obtain that share. So over here the plaintiff admitted that he and his brother had long been on bad terms, but in spite of the strained relations, the court held that this is just the case to which Section 25(1) should be held to apply. The defendant had such natural love and affection for his brother that in order to be reconciled to him, he was willing to give him his property. So this judgment can be contrasted with the first one, but the judgment of Rajlok Dabi versus Bhutnath Mukherjee, it is very important, and I'll tell you why. But before that, we see UP PCJ question of 2015, prelims question, whereby the question reads, A, for natural love and affection, promises to give his son ₹1,000. A puts his promise to B in writing and registers. This is a contract. Yes, it certainly is, as in subsection 25(1), a contract. Now, what I was talking about earlier. A question was asked in UP PCJ 1997 on the same grounds on which you find the case law of Rajlok Dabi versus Bhutnath Mukherjee. The question read, with a view to get rid of each other's quarreling nature, both husband and wife entered into an agreement in which wife agrees to live separately from her husband permanently, and husband agrees to pay her a monthly maintenance allowance of ₹500. After 6 months, husband refuses to pay the allowance, can wife enforce the agreement against her husband in the court of law decide? So in this, we need to mention subsection 25 once, firstly, and you must have realized that the facts of this problem, they go parallel to the case of Rajlok W versus Bhutnath Mukherjee that we have just deliberated on, whose facts and judgment becomes the authority for concluding that this agreement is not enforceable under section 25(1) of ICA 1872. Now, another interesting development that I would like to share with you is that in UP PCSJ 2003, exact same question was asked. I know it would be hard to believe for people who have not been through previous year questions, but I am emphasizing on this, students. Please go through all the PCSJ questions depending upon which state that you're aiming for. Go through all the PCSJ previous year questions. 1997 a question was asked, and exactly like word to word, the grounds, the facts of the problem, they were same in the 2003 one as well. The question read, being fed up with each other's quarreling nature, both husband and wife enter into an agreement in which wife agrees to live separate from her husband permanently, and her husband agrees to pay her a monthly maintenance allowance of ₹1,000. After 6 months, husband refuses to pay the allowance. Can wife enforce the agreement against her husband in a court of law? Yes, that is right. Exact same question, the same problem was asked verbatim in 2003 examination. This is how easy it is to score full marks in some questions, and you should always take advantage of that, because believe me, your competition will. Now, coming to the second exception as mentioned in the section 25 of Indian Contract Act, that is past voluntary service. So a promise to compensate wholly or in part a person who has already voluntarily done something for the promiser is enforceable. In other words, a promise to pay for a past voluntary service is binding. It is necessary to attract this exception that the service should have been rendered voluntarily and also for the promiser. Thus, in Karamchand versus Basant Kaur, where services were rendered for a company not then in existence, a subsequent promise to pay for them could not be brought within the exception. But a promise made after attaining majority to pay for goods supplied to the promiser during minority has been held to be within the exception. The court said in the latter case that it is now settled that a promise by an infant is in law a mere nullity and void, but we fail to see how an agreement made by a person of full age to compensate a promisee who has already voluntarily done something for the promiser, even at a time when the promiser was a minor who does not fall within the purview of section 25(2) of the Indian Contract Act. As at the same time when the thing was done, the minor was unable to contract, the person who did it for the minor must in law be taken to have done it voluntarily. But he has in fact done something for the minor, and if words mean anything at all, surely his case must be deemed to come within the scope of the Act. This is a very progressive judgment, and you must remember this case law. Now, coming to the last exception, and this has been a long lecture. I'm sure all of you must be waiting to get it over. So, time bar debt. A promise to pay a time bar debt is enforceable. In the case of A.V. Murthy versus B.S. Nagaswana, it has been held that the promise should be in writing. It should also be signed by the promiser or by his agent generally or specially authorized in that behalf. The promise may be to pay the whole or any part of the debt. The debt must be such of which the creditor might have enforced payment but for the law for the limitation of suits. Now, is it necessary, students, that the promise should be given by the person who was liable for the original time bar debt? So, the Bombay High Court has helped you in coming to that conclusion, whereby in Pestonji Menek G. Moody versus Bhai Meherbai, it has held that a promise made by a person who is under no obligation to pay the debts of another does not fall within the clause. But Madras High Court poses a confusion on this note, whereby in the case of Puliyat Govinda Nair versus Parika Lathil Achutan Nair, it was held that the words by the person to be charged therewith in section 25(3) are wide enough to include the case of a person who agrees to become liable for the payment of a debt due by another and need not be limited to the person who was indebted from the beginning. So if a question does come, we need to mention all these three case laws for the question of time bar debt. So speaking of question, one has been asked in UP PCJ 2013, and it said, A promise to pay our debt barred by the law of limitation has been made enforceable under which section of the Indian Contract Act? Come on, this was very, very easy. Section 25 it is. UPPCSJ 1910-1992, a mains question was asked. And this is an interesting question. I'll tell you why. The question read, A owes rupees 2000 to B, but the debt is barred by the Limitation Act. A signs a written promise to pay B rupees 1000 on account of debt. Is it a valid contract? Refer to relevant provision of the Contract Act. Now, in this section, we need to mention section 25(3) and illustration E of section 25 as we have discussed earlier. Students, if you would notice, this question is based exactly on the illustration E of section 25. Yes, it is that easy. To substantiate your answer, you can also mention the case of A.V. Murthy versus B.S. Naga Basavanna. But more importantly, we need to conclude that it is a valid contract under section 25(3) of the Act, as the given problem goes parallel to illustration E in the Act. So students, that sums up our thorough discussion on consideration. I'm sure after today's lecture there would be no question which you cannot solve. Since we have discussed a lot of concepts with a lot of case laws, I would suggest you to revise this given PPT on a weekly basis until your long-term memory has inherited the memorization. So thank you till we see each other again.